What's up, everyone? Welcome in. This is the first live I've done in a while. Glad we were able to do it. Glad we were able to get Hot Bench's Rachel Juarez on. And I wanted to bring her in immediately. First off, I just wanted to kind of add this. We are going to do a Q&A at some point during this. So any help on the super chats, obviously we'll get your question answered, but any help regardless, helping with the channel, I'd really appreciate it. All my info is scrolling at the bottom of the screen. So without any further ado, let's bring her in. It's Rachel Juarez. Hey, Rachel.
Hi, Steve. How are you?
I'm great. I know that before we get into everything, I know that obviously you've kind of been through it this last week or so. You're in Southern California.
Yep.
You are dealing with the fires. How has it been for you guys? What have you had to evacuate? What's your situation?
So we're fine. We didn't have to evacuate. We were a few blocks from the evacuation zone, but we ended up leaving town just because of the air quality. So we've been very fortunate, very lucky. My family's safe. Our house is safe. A lot of people who that's not the case for. So it's just, as a city, I think as a community, it's been a really devastating time.
And some people that have lost their property?
Many.
Really?
Yeah. Both
Crazy.
Both in the Altadena area and the Easton fire, the Altadena-Pasadena area, and particularly in the Palisades fire. I know a lot of families in the Palisades who have lost their homes, and it's going to be a long path to rebuild. Yeah. So
no easy transition from that. I'm glad you're safe and sound. Some good, some news to pass on for those that watch Rachel's show. Maybe you have seen this online. Deadline had a story. I think Variety had a story about it. There was some news in the TV trade papers that Hot Bench is moving their filming to Connecticut, of all places.
It is.
You live in Southern California. So why don't you update everybody on what's happening with you and Hot Bench?
Yeah, so you're right. Hot Bench is moving its filming to Connecticut, to Stamford Studios, which has been a long time hub of a lot of unscripted shows. And although I'm in Southern California, and although my family is going to stay in Southern California, I am going to stay with the show, and I'm going to commute out and continue to film in Connecticut with Hot Bench.
That's awesome. When does the next season begin filming? Are you allowed to?
So right now we are airing season 11. Season 12 will begin filming in March or April, and then season 12 will air in the fall.
Gotcha. So it's a hell of a commute. It's not down the street. It's not like you're going to Arizona or Vegas or Colorado.
No, it's going to be a commute, and it'll be interesting. I have little kids, so it'll be interesting to see how it works out. But I really love the show. I love the people I work with, and so I'm going to give it a shot.
Yeah. So I can't imagine it's months at a time that you're gone from your family.
No.
Can you talk about the filming schedule?
Sure. Yeah. So the way we're going to do it is we film several days at a time. Usually about 3 days at a time, and we film anywhere between 6 and 8 cases per day. So the way that it's going to work is it's going to be sort of week on, week off for, from about April until about August. So we'll film on a Tuesday, Wednesday, Thursday, or Monday, Tuesday, Wednesday, then take the next week off and then go back to filming. So I will probably be flying just back and forth each week, spend a week out there, a week back here. And it's only for about 5 months of the year. So that makes it easier as well.
So I'm going to say, so if you film Tuesday, Wednesday, Thursday, you would be on a flight back to California. I'm assuming Friday.
Yeah.
Friday to Friday probably, and then get back the following weekend and ready to go.
Exactly. So I won't be away from my family for more than a week at a time.
Okay. Nice. Okay. Let's get into what we've waited for a while now. When David Jingis first dropped the appeal that he filed in this case, I believe it was mid-November, right? Maybe was it after Thanksgiving or before Thanksgiving? I can't even remember. It was November-ish.
Yeah, it had to be November-ish because the original due date was December 24th. So it must have been right around Thanksgiving.
Yeah. So it was right around that time. And at the time I said, you want to come on and discuss it? And you were like, well, not really, because what was your explanation for why you didn't want to discuss it then?
So we did a little bit of discussion. We just didn't kind of dive into it completely because I don't practice law in Arizona. And it's very difficult when you're reading one side of a brief, when you don't have any independent knowledge of the law in that particular jurisdiction, to really evaluate the arguments. And so I kind of figured, instead of me researching from scratch Jingris's arguments, why don't I wait until Woodnick's firm files his brief and see what their arguments in response are? Because that will sort of point me towards the opposing authorities and towards the counter arguments, so that I can then evaluate both sides' arguments for myself.
And so you've obviously read Jingris's appeal. You've read Woodnick's brief. You have clicked on all the cases that were attached to it. You've gotten yourself familiar, or not all, maybe you did do all. I don't know.
Not all of them.
Not
no,
all of
many of them, but not all of them. Some of them were not necessary. They stood for kind of just general propositions of law. So you don't need to read those.
Okay. So I do want to say right off the bat here, we're going to be discussing what Jingris said, and then obviously Woodnick's response and your thoughts on everything. And, this will end up, if you're not watching this live, it obviously saves to my YouTube channel. You can watch it at any point. And any content creators that want to use my video and use your answers, I will sue your ass into next week if you do that.
Yes, I will represent you. No.
Yeah. Yeah, I'm kidding. Use all the video you want. I don't care about this fair use bullshit. No, I understand that. Well, actually, I don't understand why he gets so his panties in a wad over this, but we know that's what he does. I don't care if you use my whole video, honestly. Go ahead. But I know that a lot of people will want to listen to your answers and use those as clips and whatnot. I have no problem with that. You can use long, and you can use 30 minutes of this video. You could use 40. But what we're going to do is we're going to go over it. You're going to discuss it, and then we will do some Q&As for anybody that has questions or maybe clarifications on things as well. So, jumping right into it, do you want to give an overview of what you thought of everything that you've read so far? Or do you want to just jump into the one thing from Jingris's appeal that we can pull up and look at and just kind of go from there? What do you want to do?
I think that makes sense to kind of give an overview, because when we talked about this sort of just on the surface a couple of months ago, my initial impression was that this was not going to end up being a Rule 26 issue, a Rule 11 issue. And for those who are kind of just jumping back into this, the main thrust of Jingris's appeal was that the sanctions that were awarded, the $150,000 in fees, were awarded under Rule 26, which is a very narrow rule in Arizona law that is modeled after Federal Rule 11, that says if you sign a pleading that is not in good faith, or if you don't have a good faith reason to believe what you're saying in a written pleading only, you can be sanctioned for it. And for Rule 26 and Rule 11 only, in order to ask the court for sanctions against someone, you first have to put them on notice that you're going to do it. And they have to be given what's called a safe harbor period to say, okay, you know what? I give up. I'm going to withdraw that pleading. You're right. So that we don't spawn too much litigation about nothing, really, in essence. And so the thrust of Jingris's appeal was that the sanctions were based on Rule 26, and Laura did not receive proper notice that there were going to be sanctions under Rule 26 at issue. And Laura was not given a safe harbor period. So when I read his appeal, just my reading in the appellate brief, I said, this seems like there's kind of a hole in his entire argument, which is
imagine that.
Yeah, right. Which is that he may be right about Rule 26. I actually found some of what he said persuasive, but it looked to me like there were a whole host of other statutes under Arizona law, completely separate from Rule 26, under which the court awarded sanctions. And he really did not meaningfully address those issues. And so I kind of guessed that that would be a large part of the answering brief that Woodnick's firm filed, that it would focus on, look, we did comply with Rule 26, or we tried, but it really doesn't matter, because the sanctions awarded were not awarded under Rule 26. They were awarded under other rules that do not have this kind of safe harbor period requirement. And I love saying this, I was right. That is the main thrust of the answering brief as well. It is that Jingis really set up, and I think we see this kind of in his YouTubes and in his, kind of rants, if you will. He sets up a real straw man argument. He throws this red herring out there, builds it up, kind of twists it all around, and then says that's not right. And he may be right that argument is not right, but that wasn't really the argument that was being made. So a lot of other things, but that's kind of the 10,000 foot view.
Okay, so I know that Jingis he's either watching this right now or he is going to watch it, because I know that he is a fan of you, and I do say that sincerely. He's obviously, I know he likes to rip on anybody, content creators that talk about what he talks about, because his thing is, I'm a lawyer in Arizona and you're not, you can't possibly know what I know. So now he's matching wits against somebody as educated as yourself. You might not be practicing in Arizona. And when you did talk about this, the first time that he addressed the fact that he liked that I had you on, he did say, I agree with a lot of what you said, but some of the stuff that she said, I don't agree with because she doesn't know Arizona law. So we already know that his response is going to be talking about, well, Rachel doesn't understand Arizona law in particular cases. Is there anything that you can address in regards to that you're like, well, I actually have gotten caught up on Arizona law, so I don't think, while I might not practice out there, I am caught up on it now.
So yeah, it is definitely true that if you're not practicing in a jurisdiction, you may not, for rules that exist, like reasonable fees can be awarded, you may not have as good a sense of, well, what does reasonable really mean out there? Do they tend to award all the fees? Do they tend to award some of them? Because that's really more of a practical issue that you have to kind of be, boots on the ground in order to know.
Yeah.
But I think what a lot of people don't necessarily know about law is that when we go to write a brief, when we go to respond to issues, we understand the general law, and particularly in family law, we know the statutes in California. I'm sure he knows the statutes in Arizona off the top of his head, but we don't know most of these cases, except the very famous ones. A handful. I can think of maybe 10 in California, 20 that I definitely know because they're cited all the time. But we go and do independent research of the law and how statutes are interpreted every single day, even if you've been practicing for 30 years in a particular jurisdiction. So I went and looked at the actual cases that were cited by both parties, and that's what the appellate justices are going to have in front of them. And this is not a situation where they're going to say, oh, I have all this independent knowledge of the law that neither of these parties thought of. The appellate justices are going to read these briefs and read the cases. And that's the same position I'm in. So it becomes much less significant to have a boots on the ground understanding of how the law works in practice when you have the benefit of both sides briefing and you actually do, like I did, read all of the cases cited, or most of them.
Yeah. So do you want to just jump right into the main thing from Jingis's? So let's start with, let's do Jingis's appeal. Let me pull that up. Let's see. You got this? Can you see this? Oh,
yeah.
Wait, hold on a second. There we go.
All right. So this is page 15 of Jingis's brief. And
I don't know why it's cut off, but there we go.
No, that's okay.
How about
there you go.
Yeah, there we go.
So appellate briefs are very formulaic in the sense that there are specific things they need to cover in every single brief. Every single appellate brief has to have a statement of the case, and then a statement of facts, and then a statement of the issues. And those may sound like three of the same things. They're not. Statement of the case is kind of in one or two sentences. What is this case about? Then you have the statement of facts, obviously, which is what Jingis really focuses, a lot of his time on when he went through his own brief. And then statement of the issues, which is really how you frame the issues on appeal. And so this is how Jingis framed the issues that are on appeal. And sometimes there isn't an agreement necessarily about what the correct issues on appeal are. Sometimes the parties disagree. That's an issue. No, it's not. But here, his brief, I think, really nicely sets out what the actual issues are. And then Woodnick's brief, instead of kind of dancing around what the issues are, takes them on head on. So I just kind of wanted to start by looking at his issues and kind of breaking down the arguments.
Okay.
Issue 1, which is the first issue that I sort of got into, is about Rule 26. And he's put it in, kind of a complicated, long worded way. But in essence, issue 1 is, did the trial court properly sanction Laura under Rule 26? Right? Did it deny her the right to the safe harbor period, or did it otherwise permit a sanction under Rule 26 to be imposed when that wasn't appropriate? The second issue is, did the trial judge commit structural error, which is kind of a funny thing to see in family law. And Woodnick's brief points out in Arizona, and this is another reason it's helpful to have his brief, structural error is something that doesn't come up in family law, because structural error is typically an error with an entire trial that makes the whole thing unfair. A really good example of a structural error is not allowing a defendant to represent himself in a criminal case. That thing makes the whole trial unfair, because you have a right to represent yourself. And if you don't, it infuses problems into the entire case. So Jingis argues that the trial judge, perhaps Googling the hours of Planned Parenthood, was structural error. And hopefully people are saying, what? Because that's exactly right. What? It's not. That would require the entire case to be reheard. Issue number 3, and this is where we kind of get into the other statutes. Jingis I think only the last couple of pages of his brief are even devoted to these other statutory bases for fees. And you have these laws that are cited, Arizona revised statutes 25.324 and 25.415. And it's really important to note what his issue with the sanctions awards under those statutes are. He basically says there was no basis for such an award and no motion for sanctions under those statutes was filed. So he's really challenging just the judge's finding. This is not a hyper-technical legal point, right? That's, did you comply with the safe harbor period? He's basically saying there was no basis for such an award. The judge made a mistake. The judge awarded sanctions when that was not the right thing to do. And when you're doing that on appeal, when you're challenging something just based on the fact that it was the wrong conclusion, it is an incredibly high standard of review. The appellate court basically accepts everything the trial court says, and they defer to the trial court in every way. And they only reverse if there's a complete abuse of discretion. Like, really, it's just so absurd that the trial court has actually abused their power. And then issue 4 isn't really, I think we could skip over issue 4 because it's not really a salient issue in either one. And then issue 5 is Laura entitled to her attorney's fees and costs on appeal. That's completely collateral to the issues we're talking about. This is about this appeal.
Yeah.
So before we move on, I just kind of wanted to bring up the statutes that are at issue. And it's 25.324.
All right, that's attorney's fees. Here we go.
Yes. So this is a statute that looks a lot like a statute that exists in California, which basically says in family law, because these are family law rules, that the judge can do something that they can't do in criminal cases or civil cases. What they can do is they can consider the financial resources of both parties and the reasonableness of all the positions they've taken in the proceedings. And they can make one side pay the other's attorney's fees. It's just kind of a blanket, a blanket blank check, if you will. It's an opportunity for a court to award attorney's fees, not for something very specific, but just, I've considered the reasonableness of what everyone's argued and their financial resources, and I think you should pay some of her fees. And that happens every day in family law here for people where there's just a disparity in financial resources. If you have one person in a divorce with enormous resources and another person who doesn't have enormous resources, they often pay a lot of the fees, even if they don't do anything wrong. So it's important to understand that unlike Rule 26. ARS 25324 is a really broad fee shifting statute, which basically says I'm allowed to look at the reasonableness of every position taken in this case and decide if one party should pay the fees. Now, the other important part of this is section B, because the other component of 324 is that if the court determines that a party filed a petition under one of the following circumstances, the court shall award reasonable costs and fees to the other party. And shall is very important because shall in the law is mandatory. It means you must. The court must effectively award reasonable costs and fees. Not the court may or the court can consider, but the court shall. And obviously, one of the things here is the petition was filed for an improper purpose. Laura's petition in this case. Laura's petition was not filed in good faith. I mean, those are all allegations that have been made and that I think Judge Mata and many of us believe have absolutely been proven as well. So this is one of the statutes that we're going to look at. And it is much broader than just Rule 26, which is limited to signing a pleading. This has to do with, is it reasonable to ask for mediation when you know you're not pregnant anymore? That in and of itself, that is a position that may or may not be reasonable. And that is something that can be the basis for sanctions under this rule, whereas it couldn't be a basis for sanctions, most likely, under Rule 26. So that's the first sort of general statute at issue. Then you also have 25-415.
Here it is. Sanctions for litigation misconduct.
Yes. And again, you have the court shall sanction a litigant for costs and fees incurred by an adverse party if the court finds that the litigant has done one or more of the following: knowingly presenting a false claim, knowingly accusing another party of making a false claim, and then, really critically, violated a court order compelling disclosure or discovery. And this is where the Planned Parenthood stuff really comes in, because we know that, you know, Jingis has made a lot about the sort of shifting views about Planned Parenthood and did Mata do her own research. But Laura's defense to, you know, why she kept changing her story about Planned Parenthood was that she didn't want Clayton to know where she went because she didn't want him to be able to get her medical information. And I guess she says that because she thinks that will be helpful to her. In fact, it's the opposite of helpful, because there were discovery orders in this case that required her to disclose that information. And she disclosed it falsely. And she sent Clayton on wild goose chases to Planned Parenthoods that she never went to. And then on the eve of trial, at trial, she completely changed her story. So this is another sanctions statute. And sanctions are just attorney's fees. It's just, we call them sanctions when they are intended to punish. The prior statute we looked at, which just said attorney's fees, that was not a punishment issue. That was just a fee shifting issue. Sanctions, when you hear sanctions, it means punishment, basically. I'm punishing you for taking bad positions or unreasonable positions. So, and then there's a third statute, which I think is less, I don't even think, you can pull it up really quickly, but it's less on point here. But a third way is 25-809. And that's a third way, but it's really not, I don't think, quite as on point here. So I think just having that background on 25-415 and 25-324, again, on the one hand, this reasonableness of the positions and the financial resources of the parties, you know? Yeah. And on the other hand, punishment for bad conduct. And we know that Laura, and Judge Mata found in her ruling, claimed to be making about $200,000 a year or something close to that. And if that is true, if she didn't lie when she said that, that is no doubt part of the reason why Judge Mata found it was appropriate to award attorney's fees and sanctions, because she has the financial resources to pay them. So, all right.
So we'll go to, you want me to bring up Woodnick's?
Yes, let's go to Woodnick's brief.
All right, so here's page 16. We want to start here. All right, so here's Woodnick's briefing, and you wanted to start at page 16 and kind of go over this. So go ahead.
So as we kind of talked about last time, the statement of facts in an appellate brief is really supposed to be pretty dry. It is not typically supposed to be really spicy and out there. And this brief is written much more like an appellate brief, I think, than Jingis's brief. But this is kind of where it starts to get, to me, the legal arguments kind of start to formulate, which is that they notice right up here at the beginning that the court also awarded Clayton attorney's fees and costs based on the two statutes we just looked at, 25.324B and 25.415, with a 2-page explanation of the findings supporting the award. And that is really critical, and it really kind of underscores why Judge Mata took 17, 19 pages, whatever it was, to go through all of the bad conduct, because it is relevant not to Rule 26, but relevant to these two statutes. And when you appeal something, and there are 3 possible bases for an award, in other words, if the court could have sanctioned her under Rule 26, under 25.324, or under 25.415, the appellate court just has to find that one was appropriate in order for it to stand, right? Because it only needs one leg to stand on, you know? So what he does is he goes through that Laura, a lot of the things that Laura did, and then also starts to touch on the things that are just, you know, so obviously sanctions issues, like altering evidence, falsely responding to discovery, which you respond to under oath, right? When someone says answer these questions about the case, and you answer them under oath, just like when you're testifying. And so what we really get here is we're starting to lay out the basis for why there is more than sufficient bases to award the sanctions under these other statutes.
Yes.
All right. So
now move on to 18, statement of the issues.
Yes.
The jurisdiction. Yeah.
Right. So this just kind of says, look, they're going to take. I always think it's very interesting when parties in a responding brief, they can make a choice. They can respond to the issues exactly the way the other party has responded to them, or they can kind of frame them differently. And it's a really interesting choice, right? Whether you kind of reframe the issues or not. This tells me that, you know, Woodnick's firm was confident enough that they could address all these arguments, that they don't need to kind of like reframe the issues. They're just going to tick through them one by one by one. So they go through and they say Laura's opening brief argues 5 issues, which are the ones we just looked at, and they're going to take them on one at a time. So we start to get into the argument. And I guess we can go to page 20. Why don't we go to page 20?
Okay.
Because this is where we start to get to issue number 1, which is what we've all been saying. The court did not sanction Laura under Rule 26. Now, I will tell you, this is not entirely clear. It simply isn't. Judge Mata's order leaves a little bit, and I reprinted it too, you know, to go through, leaves a little bit to be desired in terms of explicitly setting out which statutory bases she's awarding fees on for which specific conduct. It would have been better had she said, you know, Laura falsely responded to discovery. Therefore, under ARS 415B, you know, or fill in the blank, she has violated a court order for discovery. She has done this. Under 415A, she filed a false pleading, whatever the case may be. She didn't do that. She kind of discussed all the statutes and then said, I award fees under all these statutes, which leaves a little to be desired in terms of clarity, but it's not fatal. Because all the appellate court is going to have to do is see if any one of the bases was appropriate. So here we go through first. And if I were to have one criticism of this brief, I thought they got too bogged down in defending the Rule 26 point. Because to me, this is it should have been, there's nothing to see here, folks. We don't need to worry about Rule 26. We should have covered it in 2 minutes and moved on. And they spend a lot of time looking at the Rule 26 arguments. And that's okay, but it kind of gives a little more credence to the fact that Rule 26 may be a real issue. And if it were me, I probably would have disposed of that more quickly, because the whole point here is that Rule 26 is not, it's not the applicable statute under which we should really be assessing sanctions. So page 22 is where we really get into one of the core arguments made here.
For point C?
Yes, C. So yeah. Jingis has argued, and this is one of the real kind of stretches in his argument, that if there is conduct that could be sanctioned under Rule 26, and you don't comply with the Rule 26 requirements, you can't sanction that conduct under any other statute. And that's ridiculous, because why would other statutes exist independent of Rule 26 if Rule 26 was a catch-all? And I think if we go to page 23, where this argument continues, where it starts to be clear.
To be clear, yeah.
Right. Rule 26 applies only to the signing of documents filed with the court. Right. Okay? There. And so even if you could carve out some of the things that Laura did, like signing her petition and saying, well, that should have been a Rule 26 sanction, there is a ton of conduct that we've seen. The lying about discovery, committing perjury, there's a big one, right? Refusing to disclose information she's supposed to disclose. There's a whole host of information that wouldn't even be a Rule 26 issue and couldn't even be a Rule 26 issue. So it goes on to explain, sort of at the bottom of that page, that Laura's argument seems to assume that Rule 26 is the exclusive vehicle, but there is absolutely no authority supporting that broad limitation. And that's correct. And what I wanted to point out here on page 24 is a lot of the arguments that we make in the law, a lot of the legal principles, a lot of Latin phrases, right, that sound very complicated, are really just based on common sense, right? And this is a really good explanation of that, where they argue that the court must consider the practical implications of Laura's argument, right? And so they say when language is ambiguous, you have to consider what it would mean moving forward if you took one interpretation versus another, right? So that's a legal principle that you're supposed to do that. But it's also really just common sense. You don't need a law degree to do that. You just kind of need to think. Am I making your head hurt?
No.
I know. It's, you really kind of have to think about the practical implications. And they go on to, Woodnick goes on to make a series of very compelling to me arguments that, if you adopt Jingis's argument, if you assume he's right, that the minute that Rule 26 becomes an issue, you have to comply with the safe harbor provision to get any sanctions. Then silly things would kind of flow from that. And it would turn into kind of an absurdity, because it would make every other law inapplicable, every other form of getting fees inapplicable. And all you would have to do in order to kind of cancel out every other law about attorney's fees is have Rule 26 on the table.
Yeah.
And that doesn't make sense. Nor, of course, does it make sense for it to be the case that if a Rule 26 motion is filed, all of a sudden you're able to get out of litigation and all the bad conduct you've done scot-free. How could that be the case? It can't.
Yeah.
So it's not necessarily a legal argument, but it's a practical argument. And we do make those sometimes as lawyers. All right. So
moving on to,
let's see. So 25 and 26, and I like this just because this is a good example. The sort of bottom of 25 and top of 26 is another good example of kind of, I don't know, I kind of call it folksy, arguments, right? And, what they argue here is that if the court, at the very bottom of 25, if the court adopts the argument that Laura is making, which is that once Rule 26 is in play, Rule 26 trumps everything. The phrase Rule 26 will become the family law equivalent of a Beetlejuice or a Voldemort, right? Where the magical words, and there actually is a legal principle, believe it or not, which disfavors magic words in most cases. In a couple of cases, there are magic words you have to use for certain things. But there's a legal principle which says, in most cases, you don't have to use magic words to do anything. You just have to kind of invoke the principle. And you see here, Arizona law has long disfavored magic words, right? Particularly when prioritizing formality would limit the court's ability to do what it should. So I like that because it really kind of brings in, common sense. It brings in a little bit of fun, to the brief. Anyway, it's a legal nerd fun, but it's fun,
Have you ever seen a briefing that had the words Beetlejuice and Voldemort in it?
Oh, I'm sure. I'm sure. I mean, maybe not Beetlejuice and Voldemort, but there's some really fun legal briefing out there. There's a lot of good Taylor Swift briefing right now.
Oh gosh, I can't wait.
I know, right? Where the judges go through all the Taylor Swift lyrics in briefing. I'll find some for you. All right. So, all right. Okay, so here we go to page 27.
Okay. Right here, Laura had notice and opportunity to be heard.
And what this really underscores is that the trial court, it goes back to the shall that we looked at. The trial court shall award reasonable costs and attorney's fees if it determines a party filed a petition not grounded in fact, right? And then it goes on to discuss this particular case called Grow. And, Jingis made a lot of, I watched very quickly on like 1.5 speed and I kind of skipped through it. He accuses Woodnick of basically lying about authority. And I found that to be absolutely outrageous, okay? Lawyers have to correctly represent authority. They can't lie. They can't say the Grow case says that you can do this when that's not what it says, right? But lawyers argue persuasively all the time. And framing something in a slightly different way is not doing anything wrong. And he takes this kind of, persuasive argument that, Woodnick has made and accuses him of doing improper things. It's really ridiculous. So what happens in this Grow case, which I think is really, it is not directly on point in that it's a little different, but it addresses the fact that even if you say, I want to withdraw this case completely, I want to go away, I want it to just be over.
Which is what Laura wanted to do.
Exactly. That does not mean that the court now loses the power to sanction you for things you did during the case, right? And that is one of Jingis's whole sort of, arguments. Like she just wanted the case to go away.
And Clayton wanted to continue with it.
Right. And Clayton could have just left with no attorney's fees and before anything happened. But that's not true. She dragged this guy's name through the mud. She accused him of all sorts of terrible things. He did incur attorney's fees before then. But this case is basically explaining that's not how it works. And if you see in footnote 6 here, this is kind of just an interesting point.
Yeah.
The issues in family law that we're dealing with, the sanctions awards, attorney's fees awards, there's typically not a whole lot of what's called published opinions, published cases about them that are citable, because most family law cases do not get appealed. Most people can't pay for an appeal. Appeals are very expensive. And most family law issues are abuse of discretion issues, which means it's hard to overturn a judge's decision anyway. Not all of them, but most of them. So this kind of underscores, I think, the fact that, they're citing here a case that is not citable, but doing it properly, saying here, I'm just, referring the court to this, even though it's not a citable case. And it says no other opinion adequately addresses an award of sanctions under Rule 26 after petitioner attempted to withdraw their pleading. And that's kind of the world we're working in here. There is no definitive, clear law that is going to give anybody the answer here. There are no cases that are going to give you the absolute answer, because there just aren't a lot of published cases in family law in any jurisdiction, because they're not the type of cases that typically get appealed. And if they do get appealed, they're not the type of cases that appellate courts will usually say, you know what, this is a really important case for us to publish so that everybody can learn from it and see it, and et cetera. So, all right.
Go down to D in 28.
Yes. Okay.
Rule 11.
So again, this is where I might not have focused on this as much, but this is the argument that even if the trial court had sanctioned Laura only under Rule 26, which is not what happened.
A counterfactual hypothetical. That makes my brain bleed.
I know.
Counterfactual hypothetical.
Yeah.
Okay.
My favorite thing to do in legal briefs, I think, are, because we see so many of these long kind of winding statements, is to put in a sentence like, what? Question mark? No! Exclamation point. Because it just kind of breaks up the monotony of these, I don't know, kind of silly long arguments. Okay. So the rest of this section goes on to argue that the court is empowered even if
where are we at on here?
We're just kind of going through 20. This part is not really, the specific words are not important. 28, 29, 30. 30 is the next one we're going to go to.
Okay.
It kind of says that, the court still has the power to do a Rule 11 or a Rule 26 sanction on its own, rather than a party bringing a motion. And that is what Judge Mata said she was doing. And this is really critical, this page, because what Woodnick has done here, what Woodnick's firm has done here, is compared Federal Rule 11 to Arizona Rule 11 to Arizona Rule 26. And keep in mind, these are all three different statutes that deal with sanctions for filing a false pleading without a good faith basis. And he goes through how those statutes are actually slightly different in important ways. Rule 11 expressly requires a judge to do what's called an order to show cause. This is Federal Rule 11 if we were in federal court. The judge is required to issue a document called an order to show cause why you should not be sanctioned. If the court wants to impose sanctions, you have to send out that order to show cause, which we know Judge Mata did not do. But he points out that Arizona's Rule 11 specifically eliminates that requirement. So we're still only on Arizona Rule 11. We're not even to 26 yet. But when Arizona adopted the federal rules, it said, you know what, we're not going to require an order to show cause. So, Jingis's argument that she should have issued an order to show cause is ridiculous, because Arizona specifically done away with that requirement. And then Family Law Rule 26, which is the family law version of Arizona's Rule 11, dilutes the requirements even further, eliminating both the show cause requirement and the specific sentence requiring the court to account for the party's opportunity to withdraw or correct the violation. And that makes sense, because in family law, the courts have much broader discretion to sanction parties, to shift fees, than they do in any other type of law. So it would make sense that the family law version of this rule would do away with some of the more formal requirements and expand the court's ability, particularly because of how many pro se litigants, people without lawyers, there are in family law. Laura received ample notice that the court was considering sanctioning her, and she got a full evidentiary hearing to explain her position. And then this is what I like, because it is absolutely true for a family law lawyer watching that trial. Laura received more process than most people facing sanctions. Judge Mata had a 2+ hour hearing with witnesses on just the issues of sanctions and attorney's fees. That is more process than most people get in a family law court. Laura got more process than the average person. So keep going.
To what page?
So here we go on. This is just kind of 31, 32, 33. This is showing the differences between these rules. You know, the written notice, and this is getting into whether or not the safe harbor was provided, whether or not the written notice was adequate. And again, I think they make a somewhat compelling argument that maybe written notice was provided under the relaxed standard of the family law rule. But to me, I can't believe we're already at page 32 and we're still talking about Rule 26. Because to me, the slam dunk argument is Rule 26 doesn't even matter. So we go on for another page or two. Still talking about Rule 26. All right. And then we get to page 35.
Okay. Issue 2.
Yeah, issue 2. These are going to be quick though. That's by far the most complicated issue. So issue 2 to me is the second very interesting issue, which is the fact that Jingis claims that Judge Mata Googling the rule, or the hours of Planned Parenthood, was structural error that would require reversal.
Yeah.
And they start out by noting that there's a concept in appellate law called harmless error, which is basically like if you were to review any trial court decision, you would find mistakes. There's no doubt that there'd be mistakes. You know, in long trials, you have thousands of objections that the court has to rule on. They're going to be wrong about one of them. So you do not reverse decisions when the error was harmless. When this is like, well, in the broader scheme of things, that's pretty ridiculous, right?
Yeah.
And the court must disregard errors and defects that do not affect any party's substantial rights, right?
Yeah.
Otherwise, if you made an objection that this party, should have one less minute to testify, and then they say, no, they should have one more minute, and the judge rules, and that was a mistake, you end up reversing the whole trial. That doesn't happen. So appellate courts will uphold a decision unless there's clear problems with it and what's called resulting prejudice, right? That it really impacted the proceeding.
Yeah.
And then I found this really interesting because this is the kind of research that I am not going to do on my own. As much as I find this interesting, I'm not going to undertake this on my own.
Yeah.
Woodnick has represented to the court that he could not find any example, not even one, of an Arizona court applying structural error analysis in a family law case. So, and that's Jingis's whole argument. This was structural error in a family law case.
Yeah.
Structural error is a kind of unique aspect. I think it says here, it's a creature of constitutional criminal law jurisprudence, right? There are a few civil cases where it's used, but structural error is something that so infects the entire proceeding that the structure of the whole case is wrong.
So it just in this case, just in like, we all know that, I mean, the way you're explaining it, Googling something offline or even getting it from somewhere else isn't a structural error. It's a harmless error, right?
Yes, that's the clear argument. It's not,
yeah.
I mean, they're not necessarily opposing things, but it's not a structural error.
So what would be, let's just say, what would be a structural error that Mata could have made in this case? It's obviously not being argued by Jingis because Jingis is saying her Googling is the structural error. What would a structural error look like in Mata's case if this, like, make something up that she could have done that Jingis could have said, hey, that was a giant structural error on her part, and this needs to be reversed.
That's the problem, is Woodnick couldn't find a single family law case that had any structural error ever in the history of Arizona law. If I were to try to think of one that would kind of be a little bit analogous, it might be something like if the court had the power to appoint attorneys to represent people that were facing sanctions, and they appointed someone who had been disbarred. Right?
Mhm.
Something like that. They say, Laura, you're facing sanctions, so you have the right to an attorney to help you. Or the court were to say, let's have a jury trial instead of a bench trial, even though there's no jury trials here. Something like that would be a structural error where the whole thing is wrong because you're not supposed to have a jury, right? These tiny little mistakes are not structural errors. And no doubt that is why there's no cases where structural error analysis has been.
Now, I guess if you're Jingis, you bury your head in books and try and find a case. Is that what you would do?
Absolutely. Of course you do. Yeah, that's what you've got to try to do.
And that would be presented when he responds to this,
correct.
if he finds one. Okay.
Yes. Yep. And Woodnick has done what we often do, which is smart, but it's also truthful. Could he have missed something? Yes. Yeah. So he didn't say there are no examples. He said we couldn't find any.
Couldn't find one.
And if there's 100 out there, he's going to look pretty stupid. But if Jingis manages to find one or two, he just didn't find them. So. But
if that happens, if Jingis finds one or two, he will say Woodnick lied in his brief. He's going to call him a liar.
He should be disbarred, which is absolutely ridiculous, right?
Yeah, it's exactly what he will do.
Yes, and so on the bottom of page 36, I think this may go without saying, but the reason that Jingis has kind of used this structural error analysis when it's clearly wrong, the wrong standard of review, is because it's the only standard of review where the case could get reversed without any prejudice, without showing that there was prejudice. It's the only way you could reverse a case for this tiny little mistake, right? Any other type of review, it's going to be harmless. And even Laura and Jingis must know that with this 19 pages of misconduct that Laura engaged in, the one issue of whether or not Planned Parenthood Los Angeles was open on Sundays, when she'd already lied about 2 Planned Parenthoods already falsely responded to discovery about Planned Parenthoods. It's like, it's a tiny, tiny little needle in the haystack of misconduct. It is not something that anybody could argue in good faith changed the outcome of the case, right?
Which is what and when we're done talking about the case, we'll dive into that. But it is a major sticking point because he thinks, one, she Googled it on her own time, which a judge is apparently not allowed to do. 2, her father being in the overflow room with the rest of us, even though he has no proof of anything the father said, he's going all off hearsay. Yeah. Even if the father did say, I don't know, man, this is a great case. I want to see him. I definitely think Laura's guilty in all this. Is that a reason to reverse the whole decision because her father said something?
No.
But that's what he's saying it is. Like, he's literally saying it is. That's what's so amazing about this.
If Clayton was her father, that would be a problem. Okay. Yeah. If she had if she, hosted bachelor watch parties every day and Clayton was her favorite bachelor, that would be a bias that would be. But the fact that her dad is coming to trial, even if it's because he likes Clayton, is not. I mean, judges have to go live their lives every day,
And her sister follows Clayton on Instagram. That's another big thing with him. So, she must be biased. She must be a Bachelor fan. She must be prejudiced against Laura because she's such a Bachelor fan because her sister follows Clayton on Instagram.
It's ridiculous. And, obviously they argue, which is true, that there's no evidence that that's what Judge Mata actually did. Yeah. But to be completely honest, I don't know necessarily that there's another good explanation for what she did, but they addressed that. And this was something that, I had not really drilled in on when I was first looking at things. But if you go to page 40, they go on to explain that even if she did Google Planned Parenthood operating hours.
Here it is. Assuming arguendo. Why did they
Arguendo.
say arguendo? What is
It's
that?
like assuming like hypothetically. I don't know why we use all these words.
Yeah, where did arguendo? Why can't you say assuming hypothetically the trial judge looked up the operating hours?
Exactly, right?
Yeah.
So assuming that the trial judge did that,
yeah,
there was no prejudice. And here's why. Because there are a lot of facts out there in the universe that are not reasonably, and look, in our new day and age, I guess facts are a funny thing sometimes, but there should be facts that are not reasonably subject to dispute, right? The best example I know, like that I know of one is, what was the temperature in Los Angeles on a particular day? You can go back and find that, right? Was January 15th, 2025 a Wednesday? You go back and look on a calendar, right? And so those are facts that can be the subject of what's called judicial notice, right? How would you ever get an expert to come in and prove that Wednesday the 15th, or that July 15th, January 15th was a Wednesday? Like, you don't need to have someone testify about that. That's, what do you bring in? The calendar guy who makes calendars,
Yeah.
So when you have facts like that you want to show the court, you ask the court to take judicial notice of them. You show them a calendar and you say, I want you to see that this is a fact that's not reasonably subject to dispute. The fact that Planned Parenthood Los Angeles is closed on Sundays is exactly the type of fact that would be subject to judicial notice. So what they're saying here is, if they had only asked her to take judicial notice of that fact, she would have, and we wouldn't be here. So not only is this so irrelevant to the outcome of the case, but that would have been an appropriate fact for her to consider if someone had just filed a brief about it, right? It's not like she considered something that should never have been considered, right? So anyway, I thought that was pretty interesting.
Yeah.
All right.
Well, I mean, that whole thing, like you said, the Woodnick's team did not even know until that day about July 2nd. That's the first day she brought it up. They were always looking, like you said. She had Woodnick's team on wild goose chases for every Planned Parenthood in Southern California. And then she says on the day of the trial, no, it was actually July 2nd and it was in LA.
Yeah. And I still continue, the more that I think back on this, the fact that she said, the fact that she so forcefully insisted it was because I didn't want Clayton to be able to have access to this information, it just hurts the case, because that's what discovery is all about in a lawsuit.
Yeah.
All right. So, and then on page 43, we get into, the harmless error standard applies. Again, you don't really need to be a lawyer to kind of imagine that this is harmless error, right? This is the type of thing. She did a 19-page judgment. Nobody could credibly say that if Planned Parenthood had been open on Sundays, Laura wouldn't have been sanctioned. She wouldn't have been sanctioned for all the other crap she did.
Yeah.
So.
Yeah. And that's the amazing part is I'm just, as the layperson who isn't a lawyer, I'm flabbergasted that he is so hell-bent on this Planned Parenthood notice and this Planned Parenthood note that it wasn't anywhere in the depositions. How did she know? She must have looked it up. And it's like, okay, if she did, this isn't cause for reversal, yet he is so convinced that it should be. Like, how can you and him and any other lawyer that has spoken on this has basically said the same thing? Like, even if she did look it up, big fucking deal.
Yeah,
not that big of a deal. It's not cause for a reversal. Correct.
It is the definition. Like, this would be a good example to put in law school textbooks of harmless error. It really would, because nothing, when you have all these bases and all this misconduct she engaged in, and a very broad standard for awarding sanctions, the fact that she lied about one thing when she lied about 70 other things, it is the definition of harmless error. All right.
Yeah.
So we go on. So the rest of the brief, I mean, I think it's a well done brief, but to me, I don't think that Jingis even made a really compelling case, even in his opening brief, that sanctions were not appropriate under these other statutes. And, Woodnick kind of goes through and explains, why the sanctions were awarded, why the conduct falls within the ambit of these statutes. But the one thing I did want to look at just very quickly is on page 50. Because, as we saw in Jingis's issues, right? One of the separate issues he called out was there was no motion for sanctions filed. And so how can you award sanctions under these statutes when there was no motion filed? And Woodnick takes that head on and basically says that a motion isn't required. It just isn't. So, and that is true. This is another place where family law comes in. Everybody in family law knows you don't even need a formal request to ask for fees. It's one of the things in family law where you can stand up at a hearing and say, Your Honor, we're going to have I know we're here talking about custody today, but my client needs $100,000 for fees for this proceeding, and he's litigating her into the ground, and I need you to look at the most recent financials and give me some fees. That's enough notice. As long as the court has the information, you can make an oral request. Now, whether or not the court has the correct information before it and things like that is different. But everybody knows that fee requests in family law, and apparently it's the same in Arizona, can be very informal, because requiring too much formality for those would make it difficult for someone who needs fees to even get them. Because how are they going to get a lawyer to make the formal fee request? So anyway.
Yeah.
So then we just get into, and the reason to the rest of the brief is basically the trial court was not wrong in finding that Laura engaged in litigation misconduct and that her positions taken were unreasonable. And I kind of think we've been through that so many times.
Yeah.
I don't think
we can get out of the, we don't need the.
Yeah, no, I don't think we do.
Okay.
I don't think Jingis meaningfully takes that on, nor should he, because there really is just, to suggest that this decision was just wrong under an abuse of discretion standard, right, is basically saying that Judge Mata's conclusion that she engaged in litigation misconduct, when we know she fabricated evidence, altered documents, that the finding that she engaged in litigation misconduct was so bad that it abused her discretion as a judge. Come on, not only is it right and it's been admitted, but it's not an abuse of discretion, not even close.
So there are some other things that obviously, since Jingis has taken to YouTube and become a content creator now, he seems to really have issues with certain things that he has brought up. And I wanted to go over them with you.
Yeah.
You and I have talked about them privately, but I want other people to hear this. A couple things that he's brought up and a couple things that are questionable to me.
Yeah.
Number one, he is hell-bent on getting Judge Mata removed from being a judge in the state of Arizona. Like, he thinks she's the worst judge ever. She's inexperienced. She's only been on the bench for 2 years. Boy, she made some mistakes. I'm just trying to get her to respond to me. Remember that whole thing where he's like, why doesn't she just respond to me?
And that was outrageous.
Please inform everybody why Judge Mata doesn't have to respond to him. And she's not doing anything wrong, and it doesn't make her a bad judge because she's not responding to him.
Yeah, because could you imagine if there was a requirement? This is where we kind of get into, let's take his argument and see where it would take us, and see if that makes sense. Can you imagine if parties could just say to a judge, I think you've been sleeping with my brother. Respond to me. Yeah. And a judge had to sit down and go through and deny each of those allegations. That's all judges would do, right? Judge, explain why you ruled on this objection and it seemed wrong because I think you were sipping your water and not listening at the time. And if a judge had an obligation to go through and respond to these email inquiries, no matter what, it would just cause absolute chaos. There's a right to file a motion to disqualify. And, it also should be said that I don't believe he even gave her the amount of time he said he would to respond before he took other action. But that's really neither here nor there. You have the right to file a motion, and a judge has the right to respond. To suggest that she has done something wrong, she could have responded to his email if she wanted to. But to suggest that she's done something wrong is outrageous, because it would just open the floodgates, of ex-party communications with judges, and couldn't be more wrong.
One of the other things that he's addressed quite a few times, and I haven't heard anybody online talk about this. Again, it's something that you've brought up to me.
Yeah.
Is he loves going to the robing room, which is like a message board for judges.
Mm-hmm. Yeah.
Or as you called it, Yelp for judges.
It is.
And he talks about the fact that, look at what somebody wrote. Somebody gave Judge Mata 2 stars in the robing room and talked about how she did something wrong in this particular case. And he took a screenshot of the case. He put it on his Twitter account. Can you explain to people what the robing room is and kind of how relevant it is?
Yeah. So the robing room is it's kind of like Rate My Teacher, right? Yeah. It covers all jurisdictions, all judges in all courthouses everywhere. And it just kind of puts them on a list. It doesn't even catch all of them because it's not a formal site of any kind. And you have the opportunity to rate a judge between, I think, 0 and 10 or 1 and 10, and then write something about them.
Yeah.
And I don't think there are any judges that have a positive rating on robing room. And you can imagine why. It's the nature of the internet, right? People do not go on the internet to write lovely, glowing reviews of things. They go on the internet to bash people and things. And that the robing room is no different. So, and it builds on itself, right? There's never a lot of reviews. So there may be 11 for a particular judge. A judge hears 11 cases a day, right?
Yeah.
I mean, so you're taking such a tiny sample. And the majority of things I see on the robing room when I end up there somehow is that people will say, this judge hates mothers because she didn't give me custody of my children. So they make these broad sweeping statements about a judge's bias or a judge's, which are just completely ridiculous. And they are based on the outcome of one case and one disgruntled litigant.
Yeah.
So I would encourage anybody who thinks the robing room is a good, or who has doubts, and not that there is anyone, just go on and read them. I mean, it's a public website. And I think you'll find that it's.
And he's using that as his argument. That's what's so weird. It's like, how does he not know? Because somebody, and like you said, the person who wrote that, has Jingis gone in and studied that case? Does he know exactly that absolutely Mata made the wrong decision in that case? It looks like he just screenshot a negative review of Mata and said, look, see, she is a bad judge because this guy gave her 2 stars. It's like, first off, how do you even know if what that guy wrote is true? Like, maybe he didn't understand.
You don't. I could go online today and write, I just had a case in front of Judge Mata and she took my kids away from me because she, liked the shirt my husband was wearing and she told me she didn't care about me. I could go, there's no verification process.
Yeah, there's no vetting process.
Right now. Yeah. It is Yelp. It's Yelp for judges, except worse than Yelp.
Yeah. One of the other things that he brings up a lot, and by the way, if you have a question for Rachel, put it in the comment section and I'll bring it up. Or I'll star it or whatever. One of his big arguments right now, or seemingly on his videos, is we kind of brought it up earlier, which was Laura had the ability. Laura said, Clayton's the one that continued this case.
Right.
Laura said, I want it out. This didn't even need to continue, but Clayton is the one that my client just wanted to get rid of this whole thing. And she filed a motion. Did she file a motion to dismiss in December of 2023? Yeah. So explain again why Clayton isn't in the wrong for continuing the case like Jingis seemingly assumes that he is.
Right. So that obviously, I mean, I just want to put it out there. It obviously, there would have been nothing wrong with Clayton saying, I'm happy to cut and run right now. I'm happy for this to be done. I'm happy to leave. I'm happy to get out of here. And I'm happy to have this be over. If he had made that decision, that would not have been a bad or wrong decision. It might have even been the better decision for his mental health, right? But there's also nothing wrong with wanting to see this case to the end, right? What he was put through right? These are public proceedings, right? He's a public figure. He was dragged through the mud, right? He had lots of allegations made, both publicly and privately against him, and both in the court and out of the court against him. And in his responsive papers, Laura filed her petition. In his responsive papers, he said, I already think I'm going to need attorney's fees from her. I already think there's no good faith basis for this petition. And to suggest that she can kind of allow him to litigate for 6 or 7 months and then say, okay, the gig is up, but now it just has to be over because I choose for it to be over. I mean, it's wrong, In a lot of cases, the person who is sued brings a counterclaim. They sue back. And can you imagine if I sued you for breach of contract and then you sued me back and I realized I was going to lose? I'm not allowed to just say, okay, we shall go away and now your case goes away too. No, that's not how it works. So,
and I think where Jingis is getting lost, and this comes up to something I've talked about on my podcast this week, is that Jingis, readily admits the JFC knows way more about this case from September of 2023 until he took over in March of 2024. Yet he still just goes off everything Laura tells him, and he just assumes that it's true because Laura told him it's true. He has no reason to doubt it. And then he says, why didn't Clayton just let this go? Laura wanted it to go. She was no longer pregnant. It's like, that's fine. That's what, we don't believe that was the case. But because he wasn't there from September to December, he doesn't seem to understand what Laura put Clayton through. So, of course, when she says in December, and this is something that Dave Neal and I hinted at, we didn't want to say it out loud, but we hinted at it every time. It's like, hey, if you say you're pregnant, there's literally 2 outcomes here. Either in 9 months, you're delivering something out of your body, or 2, or you're not. So Dave and I knew that there was never going to be a baby that was coming out on February 14th. It's something we talked about numerous times. It's like, does she not know what the end result is here? It's not like she's claiming he hit her, because then it's like a he said, she said. She's saying he impregnated me and I'm due. She even gave us a due date, February 14th, 2024. We all knew that she was never going to deliver on February 14th.
Right.
So when she says in December of 2023, by the way, I've lost the babies, or I am no longer pregnant, we still, I think to this day, have no idea what she claims. She's changed her story so many times. I don't even know if Jingis can say this is when she lost. But
if I was able to ask Jingis one question, that would be the one I would ask. Explain to me the timeline of her pregnancy.
Yeah, I think that's what we all want, and he will never do it.
Yeah, medically, if she were to have a very early miscarriage, that could go unnoticed, or it could be a non-serious medical event. It's a serious emotional event and a serious personal event, but not a significant medical event in the sense that, she might not need a hospitalization or doctor's care. But if she had lost twins at the time that she said she lost them next in October,
it's a medical.
That is not something where they're just gone. I mean, that's an advanced stage of pregnancy. That's a very late loss for a miscarriage.
You need a doctor to remove them. They aren't falling out in the toilet, right?
I wouldn't say that. I don't know. I'm not a medical professional, but yes, right? Like, this is not like I'm not really sure if something happened last night because I was bleeding a little bit and I'm just not sure if that was a thing or not. No. And so that would be the question I would ask him. Tell me the timeline of her pregnancy.
And it's funny because when I was talking to Jingis back in December, he had told me, I'm going to do a video on why I believe Laura was pregnant. And then, of course, he never got around to it and said, you know what, it's pointless. And it's just like, actually, it's not pointless, because this is the whole argument from us on this side, from myself, from Dave, from everybody, Megan Fox, the JFC crew. This is what we want to know. What is your timeline of Laura's pregnancy? Because we don't know. You've never laid it out there for us. And he said he was going to. It was the reason I was going to have him on my YouTube channel to do a live like this. And yet he just said, you know what, I'm not interested. I don't want to do it anymore because I don't think it's getting anywhere. And it's just like, okay, but then you can't sit here and say the JFC crew won't get over the fact and wants to live in the past. It's like, we're not living in the past. We just want answers to things we've never gotten answers to.
Yeah. I think, I think Jingis really is one of these personalities that enjoys representing the bad guy, I mean, and sort of enjoys taking the counter position and playing devil's advocate and, likes kind of standing up and saying, you all misunderstand it and I'm going to change minds. And I kind of thought, I kind of think he might have thought he was going to change minds at first. And he just had no idea what he was getting himself into. And I think there's been a little bit of change in the tenor of what he's been posting and such things like that. I mean, he's now saying, like, if I even have a law license. And I think he's saying that tongue in cheek, but also not tongue in cheek. Right. I mean, I think he realizes this is a little bit bad. Yeah. I mean, he's done some stuff that really, I think I don't think he's going to get disbarred, because I think the threshold for disbarment when you're not a previously disciplined lawyer is very high. But a lot of the things he's done would absolutely get him some type of reprimand in California.
What was interesting is when he had Laura on his YouTube channel on Saturday, the Justice for Clayton Twitter account took some clips from it, broke some of the things down, which showed the inconsistencies. And it also showed that, wow, Jingis really is unaware of some of the things that Laura said. And that the big one was on October 16th of 2023, she had filed a motion to talk. What's it called? She wanted to talk to Clayton.
It's like,
she requested mediation. It was filed on October 18th of 2023. And during that mediation, he says it in the video, Laura wanted to tell Clayton the pregnancy was no longer. Right?
Yep.
2 weeks later on the pretrial hearing, she shows up with a giant baby bump and wanted the judge to see. She asked the judge, can I stand up to show Clayton that I'm pregnant?
Right. And in her motion for mediation, or her, whatever request for mediation, she said he won't even acknowledge that these twins are real. It wasn't like, I need to speak to him about the important things going on in this case. It was, he's challenging, like, what a horrible human, and this goes back to why Clayton wanted to pursue the case. His reputation, it was at stake, and he wanted to be vindicated, and you see this a lot in civil cases. I know we're going to talk about Blake Lively and Justin Baldoni another day, but, at some point, it is perfectly appropriate for a litigant to say, you know what, I need an answer. I need an answer at the end of the day vindicating me. Right? Now, we encourage people in a lot of circumstances not to do that, right? To just kind of move on. But there's nothing wrong with that. There's nothing wrong with saying, you know what, we've gotten so far. This has so damaged my reputation. I need the vindication of seeing this through. And in this case, it really was important, because I think if the case had just kind of whittled away in December, this would be a very different situation for him than it is going through that whole trial, the public seeing Mata's ruling. And I mean, the sort of ethos on this case publicly, everybody's on his side, everybody. And I'm not so sure, I wasn't around back then, but I'm not so sure that was the case in like September, right? Yeah, I can imagine some people really believed him, but some people were also probably sympathetic to her. And if this had just kind of disappeared in December, this would have just died down. And I'm not sure Clayton would ever have really vindicated himself the way that he has now, because I don't know anybody who really doesn't believe that he was the victim of a huge fraud.
Well, I also think that there is something that at some point during that time, maybe it was November or December, where he has filed something of like, hey, I will end this thing, but yes, I want you to admit, put it in writing, I was never pregnant.
Right.
She wasn't willing to do that. So that's why he continued. So for Jingis to say, Clayton could have ended this, she tells him there's no babies. It's like, yeah, Jingis, she said there's no babies in December of 2023. But when she shows a belly in November, Clayton just wants to know, okay, well then what happened? Where are they?
Yeah, absolutely. And that would have been another way for her to just walk away scot-free, but also for him it would have been another way for him to get some type of vindication. Frankly, I don't even think that would have been as good as the vindication he now has, but that would have been a way to at least somewhat clear his name as opposed to just, entering into a confidential settlement where nobody's allowed to talk about it. We don't say what happened, and, everybody just walks their way. And, it also, I think once everything started to come out of the woodwork about, all these other people, I think there may have been an element of Clayton that wanted to kind of, move forward so that this doesn't happen again. And if it kind of lost steam in December, who knows? We might have, her fourth or fifth case going on now.
Yeah.
And, by making it, I would love to say she's not going to do this again, but who knows? Right?
Yeah. I can't, I don't know. I can't put anything past her. I have no idea. But the fact that he has a judgment in his favor, I think obviously is huge. What about something about this case being published? Jingis thinks that this case he thinks it should set a precedent. It will be published. Do you see it going that route? Anything in this case being published?
No, I don't. I don't think it's a significant. I mean, Jingis in his own mind is very significant, but legally speaking, this is not a particularly significant case, jurisprudentially, as opposed to like in the public. It is possible it could get published. If the court ends up engaging in a lengthy discussion of some of these issues, like, of course you can sanction someone under Rule 26 after they've filed a motion to dismiss, because apparently there's no published decisions on that. And so that would be a really nice kind of hole in the law where the appellate court could theoretically take the opportunity to say, we just want to make this clear, because apparently no published case has ever made it clear that, of course you can still get sanctions after such and such. But other than that, no, I would expect, frankly, for this just to be the court did not err, the court did not err. We uphold the trial court's decision.
Now, what is your overall impression of the fact that over the last 3 months, David Jingis has just decided to start up a YouTube channel, and what he is saying on there, bringing Laura on sometimes, Laura possibly starting a podcast. We've gotten a 3.5-minute teaser of a podcast that hasn't released an episode yet. I don't know if someone got to her and said, maybe you should rethink this because you're under criminal investigation by the state prosecutors of Arizona. But again, Jingis's videos, Laura doing a podcast. What do you think?
No, I mean, I'm surprised it's taken him this long to do this. I mean, this guy wants to be a star. There's no doubt this guy wants to be a star. And I think he chose the wrong method. I think he chose the wrong case to kind of like set his ship sailing. Because there's so many people out there who, as a matter of principle, are going to try to make sure he is never a star, right? It's not just that like he's not picking up a big following, but he has a whole universe of people who are so horrified that, about what he did and about what Laura did and his backing Laura, that they're not going to, people are going to be all over him. And they say, no, any press is good press, but I don't know. I think this is, he wants to be famous. I think, I know that's kind of silly, but.
Let me bring this question up. Does your opinion change being that Jingis did have his license suspended?
Oh, did he?
Yeah.
Oh, yes, it does. Absolutely. In terms of the likelihood of disbarment, I still think probably he would not be disbarred. In California, the disbarrable offenses are really stealing money from clients and really prejudicing clients, like by disappearing for 3 or 4 months, as opposed to things like publishing something that's not nice online. But any lawyer that's had discipline before, it's going to make them take it more seriously. I still don't think this is the type of stuff that would get him disbarred. I think this is the type of stuff that would get him a reprimand.
One of the other questions. Oh, this was somebody brought up. I guess this is about Mata. 5.9 out of 10 and 28 reviews. She's one of the highest rated on the site.
That would make her one of the highest rated judges.
Unless they're talking about you. Maybe someone looked up you. I don't know if they're talking about you.
No, I don't think I'm on roving room because I'm not a sitting judge in a superior court.
Yeah, okay.
Right? I mean, I don't think they have hot bench as one of the jurisdictions on there. But 5.9 is like one of the highest rated judges. And I'm going to guess that the part of the reason that a new judge has 28 reviews and a 5.9 rating is that JFC people have gone on and given her positive ratings.
Yeah.
I really do, which I'm not saying they shouldn't. I mean, it shows you what the roving room is. I absolutely believe that there are people who are following this who are saying, I love Judge Mata because she's doing the right thing, in this case. And you're allowed to do that. There's no filter. So that would be my guess. Although now I'm actually a little curious.
Yeah. Yeah. Go on.
Yeah, I'm gonna look because I don't think I've seen a judge with a new judge with 29 reviews ever.
I'm guessing. Yeah, I bet it's after. It's probably all happened. A lot of them probably came after Jingis took that screenshot of the guy who gave Mata a 2 and said that about the case, and then fans of Mata who watched the trial, either online or were there, probably went in and said she did a great job on this case.
And by the way, this is the roving room. This is the Yelp, right? I mean, there's nothing wrong. As long as you don't misrepresent your relationship with her, there's nothing wrong with saying, I watched her preside over a trial and I thought she was very fair and even-handed. That has as much entitlement as long as you're honest that you were not a participant in the trial. There's no reason that it's not appropriate to post that, just like all these other people are posting things. And I can already see a couple that are obviously people that are following this case because they talk about David Jingis and Laura.
Oh,
yeah, in the comments.
Here's a question: is it considered stealing from clients to encourage further litigation that isn't winnable?
No, it's not considered stealing. If your advice is so bad that it falls below the standard of care for a lawyer to encourage a client to pursue a case, then it could be malpractice. So then it can be, something that the client could sue you for, recover fees for, or if you sued them because they didn't pay you, you could recover your fees for. But no, it's a matter of whether or not your advice was so bad that it rises to the level of malpractice, which is basically two things. It's that the lawyer is so bad that they fell below the basic standard of care for a lawyer, and that you were damaged in some way. So probably in that scenario, you would be damaged because if they're pushing you to go forward with the case, you're incurring attorney's fees when you have no chance of winning. But it's kind of a hard call because whether or not to pursue litigation and whether or not litigation is winnable is somewhat subjective.
Next one. Do you think the county attorney is waiting to bring charges until the appeal is settled?
It could be. I don't have a ton of confidence. I know that there are other people that have surmised that perhaps, she really is going to pursue this and she's just waiting for the appeal to be settled. She's just waiting for maybe the case to get settled, even if it doesn't go all the way through appeal.
You're talking about Rachel Mitchell, right?
Yeah, Rachel Mitchell, right.
Yeah.
I don't know that she will prosecute. I think she should. But what I have seen from her, I just really wasn't encouraged the last time she went public. And I know there are people who say that they've talked to people in her. I certainly don't have any inside information at all. I don't know anybody in that jurisdiction. I don't know anybody in her office. But it just really rubbed me the wrong way that the last time she made a public statement about this was 5 days before an election. And the statement was very non-committal. It was like, we'll be making a charging decision soon. And that means a decision whether or not to charge. I mean, it can be what to charge her with, but it also means whether or not to charge. So I would hope, and that would probably be, given how much time has passed, one of the two reasons that nothing's happened yet. Either they're waiting for the appeal to finish, or this really does go a lot broader than, like, they really are putting together an enormous case. And that takes a lot of time to investigate and track down. But I don't know. We'll see.
What are the ethical considerations of a lawyer tweeting, vlogging about his own current case?
There's a lot of them, right? So, and Jingis said at one point, well, I'm not her criminal lawyer, so I'm not gonna, I don't have to worry about that stuff. Like, no. I mean, there's a lot of ethical considerations. The first one, which I think is the most important and is satisfied in this case, is does the client know you're doing it? And is it okay with them? Right? Because that's the biggest threshold. And that one is satisfied here. If the client knows you're doing it and is okay with it and approves what you're posting, then the ethical considerations basically become not doing something to prejudice your client's case. But whether or not blogging publicly about a case is going to prejudice you in an appeal, that's a decision that I feel like is kind of a decision made jointly between a lawyer and a client. There's no definitive legal answer or superior legal knowledge that a lawyer has about that. So I would have a hard time seeing him get in any trouble for publicly tweeting, doing vlogs or anything about his case. I think he could get in a lot of trouble if it ends up that Laura was not approving all of his videos, approving everything that he put up. But my guess is she probably is. And then every time he talks about another case, I also kind of wonder. I think on at least one occasion he said, I have the client's permission to discuss this. So you take him at his word. But I think if he's discussing cases where he doesn't have the client's permission, then you get into all sorts of issues with, are you disclosing privileged information? Are you prejudicing your client in any way? It becomes kind of a morass. Usually we don't like to do that. We just don't like, and you've noticed Woodnick has not gone public in any way. And my guess,
never has had anything public.
No, and my guess is, I don't know, but my guess is that that's a deliberate choice. It's the same choice I would make, that there's nothing to be gained by going toe to toe in the media with Jingis or trying to respond to his attacks on Woodnick. It's just not really what we do.
If Clayton loses appeal, can Laura have exposure to a malpro or abusive process action?
That's a great question. The answer is I don't know in the state of Arizona. Can she have exposure? Sure. But in California, those type of cases are very hard to make out. And I just don't know what the standard is in Arizona. So I don't know if it would be a good case or not. Could she have exposure? Okay, hold on. That said, if he loses the appeal.
Yeah, if Clayton loses the
appeal, then no, there's no exposure, right? Because at least for the time being, and again, it depends on how the appeal is lost, right? Most likely, I think in this case, what would probably happen is because of there are a lot of technical legal issues, the court might just actually say, Rule 26 was not followed. It should have been followed. That was the basis for sanctions, and it's reversed, and we don't need to do anything else. It's over. Then no, because you have a positive outcome for Clayton. So, you're not really at any risk for that. If the case is reversed in such a way that it has to be retried, which there aren't a lot of bases for here, but there are a couple, then it would depend on the outcome upon retrial, if that makes sense. But once you get into winning an appeal and having it retried, you're really kind of out of the zone of something that is so egregious that it could be the basis for a malicious prosecution suit.
Jingis says he's working this case pro bono. Do you believe him when he says
yes.
that?
Yeah, I do. Because I think he loves the attention. I do. And I think that he's doing the appeal pro bono. I'm not sure if he did the case pro bono, but he said he's doing the appeal pro bono.
Yeah.
And we can tell for sure he's not charging her for all the hours he spends on his own blogs and on his own videos. Clearly that would not be appropriate unless she was hiring him to do that. And I don't think that's what's happening.
No.
So I believe he's doing the appeal pro bono. I don't think he would have done the initial case pro bono because I don't think he could have known what he was getting into necessarily at that point. But once he saw how much attention this garnered, I do think it is very, very likely that he's doing the appeal pro bono because he loves the attention.
This is something we brought up earlier, but I saw Jingis say Judge Monica could address his questions by having a press conference.
That's the best thing I've heard him say yet. That's really no.
I remember him saying that.
Yeah. No, the rules for judges speaking publicly about cases are far more clear than attorneys. No, you do not speak publicly about your cases, especially when they're ongoing. 30 years after you retire from the bench and the case is over, there might be a little bit more leeway to say, like, 30 years ago, here was my experience when I was a judge, but no way. A sitting judge can never comment on a case.
Somebody brought this up. Can things he has revealed after the trial date, i.e. it was in fact her sister's sonogram and nobody confirmed, but she felt it was twins, be used against her in the case with the county attorney, Rachel Mitchell?
Absolutely, yes. They cannot, obviously, and I think this was kind of the assumption for the question, they can't most likely be used in the appeal, right? Because starting to introduce new facts that were not part of the record is really usually a no-no on an appeal. But the county attorney can go and do her own investigation and find that Laura, find all sorts of stuff that, she could find forensic proof that Laura manipulated these images. She could find, all sorts of things that nobody has uncovered yet. And those can all be part of the county attorney case because the county attorney's case, presumably, I think, would be for fraud. I mean, I think it would be not just perjury. I think it would be some type of massive fraud,
I mean, as we kind of wrap this up, thanks for the questions, everybody. I really appreciate it.
Yes, good question.
As we kind of wrap this up, I think it's pretty clear where you stand and where you think this ruling is headed. What's amazing to me is, like I said, Jingis will watch this or he'll watch parts of it or whatever. And I don't think his reaction to this video is going to be, damn, she got me. Everything she said was right. I'm going to lose. Like, obviously he's going to retort with something probably along the like, what do you think his retort to everything that you presented today would be? She doesn't know Arizona law. Is he going to go that route again?
Yeah, I think she doesn't know Arizona law. She didn't read all the cases. She admitted she didn't read every one, which is dumb. I mean, I think he showed in his first video, he doesn't want to call me an idiot, which, I mean, I appreciate that.
Well, you're not.
I don't think I am, but the fact that I have degrees doesn't mean I couldn't be an idiot, but he's already made clear he's not going to go there. And I think it'll be, she doesn't know Arizona law. She's never practiced in Arizona. She doesn't know everything about this case. And
no, the thing is, neither does he, because he doesn't know anything from September of 2023 to March of 2024.
Which is just really astonishing to me because...
Yeah, I mean, you know what? I heard you cut you off there, but I wanted to ask you that.
Yeah.
He takes over the case in March of beginning of April, end of March 2024. And as we know, this started in September when she went to the Sun. Right. And obviously, the things that were found out, we find out about Mike Maricini. We find out about a Greg Gillespie. Yeah. We find out about an HCG level that Dave uncovers, a Fiverr logo, all this stuff that Dave uncovered, the JFC uncovered. And to him, he just cares about what's happened from March on, which is like, okay, fine. But then you can't say about what happened earlier. My question is, should he have known? Should he have gone back and looked at every single thing from September to March before he took the case to have a better understanding? Or is it not his job to know everything? Because I just need to know what to do going forward.
Yeah, no, that's a really good question. He should, I do not think it is necessarily true that he needed to go back and research all of that in order to effectively represent her in the case. I am a little concerned about some of the things he says he doesn't know about because they came up at the trial, certain things where he's not really sure if she fabricated this or something that happened at this time, So there may have been certain things, I just kind of can't recall them off the top of my head, where a gap in knowledge would have actually been a problem at trial. But I'm not really sure for this appeal it is necessary for him to be up to date on every single one of those issues because that's really not the basis of most of his arguments. He really has a technical, procedural argument. And I always say technical. Technical is not bad, right? Technical is just technical. And what I think is irresponsible is the commenting so negatively and attacking people publicly for calling her a liar when he just doesn't even know if she lied or not because he hasn't even bothered to check it out, right?
Yeah. He just takes her word for it. She's not lying. She told me she wasn't.
Right, okay. Exactly. And I think she's a nice lady, and I think she was probably pregnant. So that's what I find much more irresponsible as a lawyer and as a human, to be, and not just to talk about the case publicly, because all right, whatever, do that, but to be attacking people in the media, to be attacking JFC, to be attacking, Woodnick, to be attacking Clayton. Dave. And then when it's like Dave, I mean,
but Dave's his biggest attackee.
Exactly. So to be attacking those people in the media and threatening lawsuits against people and then saying, oh, well, I don't really know if she lied about that thing because I just don't really know I don't really know all the information from back then. That's pretty outrageous because what people are getting attacked for saying is that she's a liar. And I mean, I would feel confident saying she's a liar and not scared of defamation because we have proof that she lied, So,
well, if you were to take over the case in March, if you were Jingis, what would your procedure have been going forward? Would you have wanted to get yourself well versed in everything that happened before you took over?
Of course. Yeah. I don't know how much I would have known at the time to go down the rabbit hole of social media and stuff on the case, but certainly I would have gone through the whole trial record, up to date, because he knew that that's what the sanctions trial was going to be on. It was going to be on the litigation conduct for the entire trial. So to say oh, well, I didn't need to know what happened back then. No, you're having a trial about what happened back then. That's really what this trial is about. So I would have, I wouldn't have taken this, but, there's nothing wrong with him taking. People who lie deserve representation too. So I don't want to bash a lawyer for taking on a client that has lied. You can't do that. But it's how he's put himself out there that is so bad, I think.
Can the appellate court expand the sanctions or impose new ones?
So the appellate court has the ability to award fees on appeal to either party. But the appellate court cannot sort of add new sanctions or say, I'm going to add an additional sanction for what happened at the trial court, because that's not an issue on appeal. But the appellate court does have the ability to award fees, the appellate fees, to one side or the other. And both parties address that very briefly in their papers. I kind of blew by that stuff because, that's going to be a quirk of Arizona law. What is the standard for fees on appeal? It's not really all that interesting. So I guess the answer is no, they can't add more sanctions, but there could be more fees awarded to one side or the other.
How is Rule 26 even an issue when Clayton withdrew the Rule 26 motion?
I mean, that's what Woodnick is saying. So the reason it's an issue and that it can be an issue, even though he withdrew the motion, is because a judge has the ability to what's called sua sponte, which is a judge on their own, sua sponte, bring a Rule 26, I don't know what the word is, right? To sort of initiate Rule 26 sanctions on their own without a party ever bringing a motion asking for the sanctions. A judge can say, I think what you're doing is so outrageous. I want you to tell me why you shouldn't be subject to Rule 26 sanctions. And so that's kind of what's at issue here is I think everybody agrees that if there were Rule 26 sanctions, it would have been on Judge Mata's sua sponte effort, not on the withdrawn motion, because that motion, you're absolutely right. That was withdrawn. That's done.
What are, if any, legal ramifications that can be brought on Laura for manipulating, doctoring both financial and medical documents? She impersonated doctors and lawyers in the past.
Yeah. I mean, it's criminal. It is.
So that would be something for Rachel. That would be something if Rachel Mitchell charges her, that would be in her charge.
Absolutely. Yes,
We have
altering
found
documents.
she did this.
Yeah, I mean, these are not, these are not murder charges, but those are all like high level misdemeanors, doctoring financial records for presentation to a court. It's similar to cases where people manipulate their, financial records to get a loan from a bank, like we saw with the Chrisleys and stuff like that. That's a crime. It's fraud. There are also the legal ramifications from that happening in this case, because manipulating and doctoring those documents to the extent they were court exhibits and to the extent that they are sort of relevant to the litigation conduct, that's one of the bases for sanctions here. That's one of the unreasonable things done, that kind of pile up in terms of sanctionable conduct.
I think early on you might have said this in regards to whether or not charges would be brought up. You said, look, if she is charged by Rachel Mitchell, it's not going to be because she lied on her oath. It's because that happens plenty of time in family court. Like, people lie all the time. You don't get charged by the county attorney for lying. I believe you said, look, if she gets charged, it's going to be because they kind of found a bunch of things that they're going to go after her for.
I think so, personally. I mean, I don't know that for sure. And it is certainly possible that this could kind of be an Al Capone situation where they finally get the big fraudster on, tax evasion, right? Or they finally get Laura on perjury, right? Because they can't put together, for whatever reason, a massive fraud case. But I would be surprised if they move forward with an entire criminal prosecution on perjury. It's just very hard to prove, and it's the type of thing that would result in a lot of selective prosecution, I think, is probably one of the best ways to say it, because I think there's a lot of perjury, big perjury and small perjury, that goes on, right?
Yeah.
And it just isn't really done. I'd be surprised. It's not impossible, but I would be surprised if she took all this time to put together a case and the only charges were perjury and maybe like doctoring, evidence. That would surprise me. It's possible.
How often do fees for appeals get awarded? Do you think it is likely in this case?
The answer is I don't know. In Arizona, I probably should have read that, all the appellate briefing on that. In California, it's not common, but it's more common in family law, because all the family law statutes that apply to the trial court can apply to appeal. So I don't know that. I mean, Jingis seems to think he's going to get his appeal. He thinks he's going to win, which is ridiculous, but he also thinks he's going to get all his fees paid. And that would really surprise me. I don't know the standard under Arizona law. If there's a prevailing party fee, then if there's prevailing party fees, whoever wins gets their fees paid automatically. Then certainly whoever wins is going to stand a good chance of getting their fees paid. But absent that, I'd be really surprised.
Well, that was the last thing I was going to ask you was, looking over everything now, seeing his appeal, seeing Woodnick's response.
Yeah.
Do you think his argument was good enough to where you think the 3 appellate judges are going to say, yeah, we're reversing this? And remember, if it is reversed, it's not because the appellate judges have said, hey, she was pregnant. This is all we're throwing out. This is all based on essentially a technicality as well.
Right. The chance that this would turn on the appellate judges saying, I find Judge Mata's conclusion that she was not credibly pregnant to be an abuse of discretion, I'm reversing on that basis, I think is virtually zero. I think it's just not going to happen. So if they do win, it is going to be it's going to be because they find that somehow the fees, I think it would be because they've determined the fees were awarded under Rule 26, and the Rule 26 safe harbor was not complied with. To me, the only issue that looks like it has any chance to survive is if Jingis is able to persuade the court that these fees were awarded under Rule 26. And I don't see the basis for that conclusion, but that's the only pathway to victory I see. I think these other pathways, the structural error is ridiculous. The fact that there wasn't sufficient evidence to sanction when it's an abuse of discretion standard is ridiculous. So, yeah.
So Jingis now gets to respond to what Woodnick wrote,
Correct.
and then that's it. And
That's it.
He'll ask for oral arguments, right? And that'll be in a couple months, probably.
Yeah, and there's usually an oral argument as a matter of right.
Will that be streamed? Will that be streamed, or we get audio of it live, or maybe right after it happens? Like,
I don't know in Arizona. A lot in federal court, the law you can stream a lot of them. I mean, the Supreme Court streams, appellate or Supreme Court arguments. Yeah, I mean, I think this could take a while, and we talked about this a little, but the appellate arguments can range from like really fascinating. Like I think Supreme Court arguments are super fascinating, right? I mean, they're really engaging and really, they ask questions and hypotheticals that are so interesting. They can range from that to like the most boring thing that you could ever imagine. Because if it's not, and this is where the name of my show comes from, Hot Bench, right? If it's not a hot bench, which means a bench that's asking a lot of questions, then it's 20 minutes of Jingis like reading his pre-canned speech, and then 20 minutes of Woodnick reading his pre-canned speech, and then they sit down. So it could really run the gamut from like very engaged and interesting and asking all sorts of, counterfactual, hypotheticals and things like that to very boring.
So what would some of the appellate judges be asking during the oral arguments if they were to pepper Jingis with questions, or Woodnick? Like, what would they be after? What are they looking for?
So I would be asking, because we know that there is no definitive law on the issue of this kind of overlap with Rule 26 sanctions and other type of sanctions, they'll be basically saying to him, they'll be basically putting Woodnick's argument to him, right? And saying, think about this. If we take your position to the logical conclusion, right? If we assume you're right, and that once Rule 26 motion has been filed, all fees or all sanctions require a safe harbor. That would mean, and then there would probably be a, for instance, in a case where someone did X, Y, and Z, they couldn't be sanctioned, right? Where someone, beats up the judge after the Rule 26 motion is withdrawn, they couldn't be sanctioned. How is that? How can you possibly defend that being an appropriate outcome? It's kind of things like that, and similarly, the appellate courts will usually put it to both sides. They'll probably say similar things, to Woodnick. Isn't it unfair if you file a Rule 26 motion and you don't give notice to then just file the same motion under a different statute to save yourself? Isn't that kind of unfair? Doesn't that kind of make Rule 26's safe harbor irrelevant? So they ask those kind of questions, right? And and then sometimes they'll ask them questions about the cases and stuff, but it's typically a time to kind of go outside the brief and to kind of draw out the arguments and see what's right.
So you're under the impression that he's probably not going to win this appeal, but after the oral arguments happen, say they happen in a couple months, we're going to get a decision before the end of 2025, right?
I would think so, yes.
Because
this is not a particularly complex appeal, and the record is not particularly huge compared to a lot of cases you imagine a lot of the huge cases that get appealed, like Harvey Weinstein. Like, think about the years of that case, and a however many month trial, the record is comparatively small here. I would imagine we would get a decision by the end of the year. And again, I think there's a good chance the decision might just be like judgment upheld. I mean,
that was something I asked you, and I guess explain it. And I promise we'll end with this. Yeah. When the appellate judges rule on this, is this going to be a Mata 19-page, this is what we think, or is it just like, yeah, we're upholding the decision by Judge Mata, move on? Like, is it going to be something simple, or it's obviously hard to predict, but what do you think?
Very hard to predict. A lot of times appeals in cases like this, when they're not, if this were a case where there wasn't a bunch of attention on the case, there would be a very good chance that if it was upheld, it would just be, I wouldn't say nothing, but it would be very short, right? The trial court did not err. The trial court did not do this. The trial court properly awarded sanctions under this statute. Therefore, we uphold. If it's going to reverse, or if the appellate court is going to reverse, or if the appellate court really finds these issues like engaging and wants to create a published opinion, then you're going to see the type of cases that are cited in these briefs where they go through the whole thing. Here's the history of the case. Here's the relevant law. Here's our analysis, blah, 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 blah. So it's hard to know.
Yeah. And I think if they do uphold it, they wouldn't have a long explanation, right? They could, but you don't think they would?
They could. It's less likely, right? Yeah. The reason to uphold it would be to basically say, we're going to uphold it, and we are going to explain that it is totally appropriate to award sanctions under a different statute, even after a Rule 26 motion has been withdrawn. But the chance of that is less likely, I think.
Okay. And if it is upheld, Jingis has mentioned possibly going to the Supreme Court with this, for the Supreme Court to look at the case after he's already lost in the trial on June 10th. And then lose the appeal. He says it's not necessarily over.
Yeah.
Because he has a problem taking the L and things. What do you think the chances of that happening are?
I mean, this is also dependent on what type of, most Supreme Courts do not have, or most highest courts, because, they're not always called the Supreme Court. Go to New York, the lower courts are the Supreme Courts, and it gets all complicated. Most highest courts in a state, in jurisdiction, you don't have an automatic right to have your case heard by them. You can, theoretically have them decide certain issues and, kick it back down, but there's no automatic right to have them fully take up your entire case, right? Because otherwise everybody who lost an appeal would go to the Supreme Court. But I don't know what the standard of review is to get your case up to the Supreme Court of Arizona. If it's an appeal as a matter of right, it looks like there may be, yeah. So it looks like they might have they have a right to obviously ask the Supreme Court to review the decision. I just don't know what the chances are that the Supreme Court would be allowed to kind of decline to take it up in Arizona, because I don't know how broad their jurisdiction goes in terms of taking cases or not taking cases.
Well, this is a fascinating 2-hour conversation. For those that don't know, you have agreed to come to the fan appreciation party this year.
That's right, I have. I will be there.
It looks like, and you've looked. I believe you looked at your schedule to make sure that you're not filming.
I did. And in fact, they just changed the schedule. And I said, oh no, and it's still fine.
Okay, still fine. Yeah. So you're going to be there. I'm telling you right now, there's a lot of people coming to the party that I think were in the chat tonight. And you are going to, probably have to talk about this case more.
By the way, it's such a cool thing that you do that, I think. It's really neat. I didn't know that was something you did. And that's really cool. It's a wonderful thing to do for your fans and for the people that love you. I think it's awesome.
Yeah, no, it really started out because it started on my 40th. It was the week after my 40th birthday. And I've never been a birthday guy. I don't care about, hey, it's my birthday month. Everyone, look at me. It's just what a lot of people do. And I'm just like, I've never cared about my birthday. But when my 40th rolled around, I said, I'm going to go to Vegas and I'll open it up to anybody that wants to show up. And I think we had like 30 or 35 my first year. And then it just got progressively bigger. This is the ninth year of it. For the first 7 years, it was in my room at Mandalay Bay. I just had a suite, a very enlarged suite that was about 1,900 square feet. So we'd have it in the room. Yeah, it was a nice size room. And it had a media room in the suite. And then last year, and then it just got too stuffy in there because I started allowing more people and I was just running around sweating the whole night. So then last year I moved it to the Venetian and we had it at a restaurant, which was great. But then this year, because it's my 50th as well, I was just like, this is what I want to go all out for. So next year, I'm definitely downsizing again. It's going back to probably the Venetian next year. But this year at the House of Blues, I'm so glad that you can make it. And I just wanted to prepare you because people know you're coming now.
No, it's going to be fun. I'm super excited. And I'm a Vegas person too. So it's fun.
Finding out from you that you're a craps player, that's even more awesome because we're definitely rolling craps that weekend at some point. Maybe after the party, we go straight to the craps tables. But that'll be fun. Can't wait.
I love it.
Rachel, thanks for coming on. You're probably coming on again next week, just on audio. I definitely want to talk to you about the Blake Lively, Justin Baldoni thing, and you've read the Rachel Lindsay. You haven't. Did you read Did you pull up the paperwork, or you just read the story?
No, I haven't pulled up the paperwork. I haven't pulled up the judgment, but I've read what she has said, and that I think there's a lot to read between the lines that gave me a much better idea what actually happened than just listening to what had been reported prior to her speaking out last week.
Interesting. Yeah, because the last that we had heard was he requested, I think, $16,000 a month in child support. She countered with 10, and then the judge said 13.5, like basically gave him in the middle. And then all of a sudden we find out that the divorce is finalized. She owes him $500,000 less the 3 payments she's already made to him. So like $466.
Yeah.
She owes him $230 this week and $230 next year, and they're done.
Yeah.
And wiping their hands of everything. So what, like, we'll talk about that. Like why go that route? Why not just ask for $13,000 a month until whenever, or what he was getting, which was spousal support. Just real quick, what is spousal support? How long would it have lasted? How long do you get spousal support for?
So in
However many years you were married?
Yes. No, in California, if your marriage is less than 10 years, which I'm sure theirs was, right?
Yeah, I think it was 4 or 5. Yeah.
Yeah. You get spousal support for half the length of the marriage.
Half the length of the marriage.
Right?
Okay.
Once you go beyond the 10-year mark, or approximately the 10-year mark, it's a different calculus. But the rule of thumb for 0 to 10 years is half the length of the marriage. So he's probably been getting spousal support for close to that. But my guess is, especially when you have short marriages like that, I bet the thought of paying spousal support to her was so distasteful. She wanted to write a check and be done, not have to write him a check every month.
Yeah. Okay. Anyway, Rachel, thanks so much for coming on. Okay. Thank you everyone for the questions, for tuning in. I really appreciate it. This will be saved on my YouTube channel. You'll be able to access it fairly shortly, I believe. So again, we'll talk to you again soon, Rachel. Thanks again.
You got it.
Thanks everyone. See you.